Hello and welcome to IBTimes TV. I'm Leanna Brinder, business editor for the International Business Times. Joining me now is Ali Akram. He's a solicitor and barrister at LexLaw. So hi, thanks for joining us.
Hi.
Well, we want to look at the legal side of this mis-selling derivatives scandal, and a large proportion of people that were mis-sold this product was in 2006, 2007, 2008. Can you tell me a little bit about why this is now becoming a major concern for people's legal rights?
Well, small businesses' legal rights are time limited. They run 6 years from the date of the first presentation. So ideally, we want to capture people's claims 6 years after the bank first started discussing these products with them. And what's happened is that the banks have constantly delayed things, including in the review, in order to allow people's claims to become time barred, which completely suits them.
And so because of that, are you seeing a flood of maybe complaints or people coming to you for actually going through litigation rather than the review?
Yes, we're quite surprised that the government and the FCA announced a scheme which allowed the banks to deal with their own wrongdoing. And it's actually not quite surprising, given that the banks have been allowed to review their own wrongdoing effectively. It's led to a large number of people continuing to want legal advice and to initiate legal proceedings in spite of there being a review scheme that's been announced by the government and the regulator.
Okay, so in terms of redress being offered through the review, yes, one would say it's very meagre. It's only £2 million really that has come out, some of these redress offers. I think it's just over 30 cases, whereas there's thousands of businesses still waiting for a decision. So what have you seen in the terms of redress or settlements offered when you go through the courts for this kind of topic?
Okay, well, there is a direct comparison that can be done here. There's 32 businesses, as you mentioned, Liana, and the redress that's been paid out in settlements via the review scheme is £2 million. That's an average of £62,500 per business. If we look at one particular bank, Lloyds Bank, figures released very recently reveal that they've paid nothing out under the review scheme, yet they've paid out £73 million to set up and administer the review scheme. As I've long felt, the banks are spending millions of pounds to save billions of pounds. And if we compare litigation to the review scheme, the bank that we've just mentioned, Lloyds, have paid well over £1 million to just one of our clients who instructed us in January of this year. That compares quite catastrophically for the banks to the way that the review scheme is being dealt with. And the FCA should sit up and take notice of this fact.
Well, in terms of, I suppose, a litigation side, is there a way that businesses can actually protect their legal rights, but not necessarily go through the courts straight away?
Yes, there's a number of options. The review scheme is very one-sided, so litigation can be used to, I can't give away too much of the tactics that we deploy at LexLaw, but litigation can be used alongside the review process in order to gain a better likelihood of redress in the review process. Further to actually issuing a protective claim, there are other steps that can be taken. For example, agreeing a standstill agreement with the banks. However, bank customers must be made aware that the banks will delay and take their time to negotiate standstill agreements on the basis that they would prefer the customer's legal rights to become time barred.
Well, one of the more worrying elements to the whole scandal is about banks' business relationships with these companies, because we talk about them looking for redress, but at the end of the day, they're working people, and they need to be able to then go back to work afterwards, carry on, build their business and their livelihood. So, I mean, I've heard some stories about how maybe business relationships have been very much affected and there's been some kind of worrying behaviour. Can you maybe give me some examples of that?
Yes, I can. I mean, there's a number of examples I can give. And we've written recently to the FCA to highlight failings in the review scheme itself and abuse of it by the banks. To highlight one example, in a case that we settled recently for over £1 million, the client has been asked by Lloyds Bank to end its future banking relationship within a period of 3 months from the date of the settlement. This is quite devastating to the customer who's banked with Lloyds Bank since 1989. And it's almost like the banks have played a game of football with us and have lost and are taking their ball home. To give you another example, the bank, another bank has classified a customer within the regulatory structure as an intermediate customer. That classification was very clearly wrong. This was a family of private individuals. Having misclassified them, they now have classified them as sophisticated customers, using the fact that they were classified as intermediate several years ago. And that's just another abuse of the review scheme that the banks are doing on a daily basis.
Well, I know there's a lot of people in the industry that are actually calling for the FCA to really, strengthen or actually implement some force in terms of getting the banks to move more quickly. Would you say that the FCA maybe themselves have dropped the ball slightly over the last few months? Once they've set up the review scheme, think, oh, it's all okay. What would you say that their kind of stake in this whole process is?
I think the FCA, or the FSA as it then was, when they initiated this scheme, it was flawed from the outset. To allow the wrongdoer banks to review and deal with their own wrongdoing, to allow them to choose and select and appoint their own independent reviewers, suggests there was minimal supervision of this process by the regulator to begin with. I believe this is the first time in regulatory history that the regulator has allowed a bank to deal with its own wrongdoing.
So thank you very much for joining us. And that was Ali Akram. He's a solicitor and barrister at LexLaw.